everyone. Welcome to Dialogue. I'm Tian Wei, coming to you live from Beijing. China is responding to public concerns over miscarriages of justice. New guidelines are being issued to remind courts that guilty verdicts should be based on full facts and clear evidence. Those responsible for verdicts, from judges to prosecutors, will also be given lifelong responsibility for their decisions. So will the new guidelines lead to greater justice and fairer punishments? Are further reforms needed to restore total trust in the legal system? And how should China try to correct possible miscarriages of justice in the past? To answer all of these questions, I'm joined in the studio by Professor He Jiahong, who is from the Law School of Renmin University. Welcome, Professor.
Okay.
And we're also joined by Lex Smith, who is a foreign legal consultant now working here in China. Welcome as well, Professor.
Thank you.
Before we go to a discussion with the two of you, gentlemen, let's take a look at this background report.
One miscarriage of justice can easily change a person's whole life. China, for the first time, has issued guidelines to prevent wrongful or unjust court judgments. The guidelines, released by the Commission for Political and Legal Affairs of the Chinese Communist Party Central Committee, stipulate that judges, prosecutors and police will bear lifelong responsibility for their roles in wrongful judgments, and the court should not issue judgments based on insufficient evidence. The guidelines come in response to increasing public pressure for judicial fairness following several high-profile judicial scandals. Last week, Yu Yingqiong, who served 17 years of a life sentence for murdering his wife, was freed after the court ruled that the facts about the alleged homicide were unclear and the evidence inadequate. In another prominent case, Zhou Zhouhai from Henan province was convicted of murdering a fellow villager. After languishing for more than 10 years in jail, he was declared innocent and released when the alleged victim turned up back at home. Earlier this year, President Xi Jinping called for efforts to build a just, efficient and credible judicial system. The strong wording of the newly released guidelines is seen as testament to the government's willingness to uphold justice and address public concerns. But the proper implementation always remains the key to reducing wrongful judgments and boosting public trust.
He Jiahong, Lex Smith, welcome to Dialogue. First of all, I need your help, Professor He, to clarify something for our audience who are watching our program from outside China. Why is it is by the Commission for Political and Legal Affairs of the Communist Party of China that issued this specific guideline about how to implement the law? What exactly is the relations between the political parties here in China and the rule of law in this country?
Because in China, Communist Party is the ruling party. So all the legal works should be under the leadership of the Communist Party. The commission you mentioned, in fact, it's very difficult to translate into English, but we just call it commission. The commission is the central authority of all legal works in China. In China, we have the Supreme People's Procuratorate, the Supreme People's Court, and the police authority, that's the Ministry of Public Security. Let me draw this picture. It would be easier for people to understand. Right. The president of the Supreme People's Procuratorate and the president of the Supreme People's Court are all vice chairmen of this commission, and so as a Minister of Public Security. So you can see that's a collective leadership for all the legal works in China.
And therefore, if the Supreme People's Court and Supreme People's Procuratorate are drawing specific guidelines about how to implement the specific law, then they are playing their specific role here. This is how we understand this comes out.
Right, exactly. That commission is a policy-making agency. It gives the outlines very abstract. So currently, the Supreme People's Court and the Supreme People's Procuratorate are drafting a more detailed guidelines for the trial works nationwide and the Procuratorate work nationwide.
Does this has anything to do that we need a guideline and we need further details about the guideline, about how to implement laws. Does this have anything to do, Mr. Smith, from your understanding about the nature of Chinese law? Some describe Chinese law with a lot of generalities and also flexibilities, and therefore there could always be so many different interpretations about the law.
Well, it's definitely true. I guess what I would like to see more happen is to see more kind of a guidelines set up, more everybody follows the same way of doing things, more uniformity. So from province to province to province, the different agencies, the police do things the same way, the court does things the same way, everybody does things the same way, so you always know where you stand, and it makes it much more easier for the police and everybody to
Is it possible,
law.
even with this guideline and further details from Supreme People's Court and Supreme People's Procuratorate?
First, I just want to clarify one thing. The guideline itself is not a law.
No.
It's just kind of policy. And in fact, that's a restatement of some basic principles in criminal procedure law, such as presumption of innocence and the exclusion of illegally obtained evidence, and also, to give the weight of evidence in criminal trials. But only those guidelines and only those even detailed guidelines by the Supreme People's Court and Supreme People's Procuratorate cannot prevent wrongful convictions effectively. We have to trace back to the causes.
What are the causes then, Professor?
I think that's multiple causes for wrongful convictions. Since 2006, I have been leading a group of researchers conducted an empirical study of wrongful convictions in mainland of China for 8 years. So there are many causes, even for one wrongful conviction, we can see several causes working together. Such
Give me an example.
Yeah, for example, that attaching too much attention to fighting crimes. So this is a mentality traditionally in China among the police, among prosecutors, even among the judges. And also the model of investigation is, we call it that from confession to evidence. So they give too much weight on confessions. So they would get confession first and then to collect evidence to support the confession. And another problem is we have to admit the torture, illegally obtained evidence that torturing the suspect and other ways. So this, let me give you an example. We collected 50 real cases with a charge of murder and rape happened between 1980 and 2006. Among the 50 wrongful convictional cases, we saw torture or some sort of torture in 46 cases. And also, we saw that the false confessions in some 47 cases. So you could see that more than 90% of those wrongful convictions, we could see the false confessions and torture or other kind of illegal activities.
These are quite distinctive characteristics of those cases.
Yeah.
But on the other hand, we do see an effort coming from China's legal circle trying to correct that with this guideline, for example, and some of the specific quotes I could get from the high officials coming from China's legal circle. For example, Shen Deyong, who is the executive vice president of the Supreme People's Court, he called for efforts to prevent miscarriages of justice. And here's what he said. He said, it is even preferable, in an article he wrote recently, to spare guilty people than to hand down wrongful punishment to the innocent. Well, for those who might not necessarily know the percentage of miscarriages of justice here in China, it is very hard to understand this specific sentence because this, in a way, seems to indicate to give those who might be guilty a chance of being innocent if there is not enough evidence. And yet people might fear this is going to create negative possibilities in the society. society.
Well, it's a
just
very
it.
similar argument in the United States all the time about the death penalty, back and forth, back and forth. But you do find, like the Project Innocent, since 2011, they've exonerated 318 people, and 18 of those people were on death row, all on DNA evidence, or they also some help other types of cases. So I've worked with cases like this, and there's so much disparity too as far as the representation of the clients. So you have to be, to me, I'm very strong feeling about this particular situation. I know, I've seen how you almost could say money buys as much justice as money can buy. So you have to know, like, this unfairness in who's representing the defendant and the prosecutor. That's why at the United States they have public defenders appointed. They, you have the right to the Miranda rights under the Fifth Amendment. You have the rights to
Right.
have an
So your
attorney.
point to this is?
Well, I think there's you need China is developing this very rapidly. They're looking the same way. They're saying there are these problems with these wrongful convictions, and we need to look more closely at who's being represented. Like if you have a small town in a province, perhaps there's no attorney there to represent somebody who's been accused of a crime, or you might have a situation. I think in China there's only like something like 200,000 lawyers now practicing, and they've only been working for about 30 years in this kind of area. But if you're a young attorney or an inexperienced attorney or even experienced attorney, what kind of case are you going to take? A very unpopular criminal defense? Or are you going to do something else you make more money at, and people are not going to get upset with you?
So what you're saying is there might be a possibility of lack of legal aid for those who can be quite innocent, and yet eventually, as a result, they were being convicted.
Exactly.
So that's your point. But on the other hand, people might fear there is also a danger if those who are really guilty are being presumed innocent.
I think this reflects the changes of value determination in our criminal justice, because it reflects the dilemma all the criminal justice system in the world are facing. Sometimes, with a shortage of evidence, although we all say we want sufficient evidence, but in some cases, the evidence is not sufficient. So the facts are not clear. So what the decision should be, there is always a risk that the judges would make a mistake in one way or the other. So one way is to get a guilty person go free. So we would call it that wrongful acquittal.
Right.
Then the other way is, to convict an innocent person. So these are two evils. So how to strike a balance between that? In China, because we used to attach too much attention on the fighting of crimes, so people would think, when we face a dilemma, probably, that letting guilty person go free, it will harm the public interest, the social justice. But let some innocent person be imprisoned, that's an individual. So they say that's a lesser evil. So some prosecutors, including some police officers, would reflect in this way that I would rather to convict him.
This is certainly very controversial, not only in this country but also elsewhere in the world. For example, in the United States, you recently have an acquittal case, which of course stirred such a big roar inside the society, whether it is a racial issue or it is only a legal issue.
Well, the people who actually watched the trial, and I think it was a good thing they put the trial on live TV every day. You could watch what the lawyers did, what the judge did, what everyone did. It educated our population. First of all, many people have no idea what happens in the court system. But it was, I think to me, it was obvious to me that the prosecutors did not prove their case. The evidence just was not there.
For Zimmerman.
Yeah, they interviewed the jury members, and they said, the evidence just wasn't there beyond a reasonable doubt that he was guilty. And the judge instructed them, if you have a reasonable doubt, you have to acquit him. There's just there's no way around it. To me, putting someone in jail, the death penalty, or whatever, it's such a, once you're there, it's really hard to come back and say, okay, I was not guilty, to appeal it. So you want to make sure things are really done right the first time.
I think that, for the Zimmerman's case, that Of course, it's about the jury trial in the States, but I think the judge in the case did not give a very good instruction to the jury, especially about the burden of proof, of burden of going forward with evidence. You know, if the defendant said that self-defense, so the defendant should bear some burden, you know, to prove that.
Well, that's certainly a very interesting case.
But
we could discuss that case for about
no.
20
Okay, I
minutes
would
or
not
so.
talk about that. But
Right.
I have to finish the argument. I have to say that for the value determination in China now, it has been changing from attach too much attention to the need of fighting crimes. You know, so we say wrongful conviction is more harmful to the society comparing with the wrongful acquittal. And you know that Blackstone, the British jurist 200 years ago, said a very good sentence. He said that it's better that 10 guilty persons escape than one innocent suffer.
You know
So
what?
now Chinese people now accept this idea. So as Shen Deyong, Vice President of Supreme People's Court,
what
said.
Well, this is a very interesting point. On the other hand, you also see with these awareness being raised over the past few years, there has been retrials of previous cases. For example, one of the recent one we also mentioned in the background, a gentleman was being convicted of so-called accused of killing his wife. He's in prison for 17 years, if I remember right.
Yeah.
And eventually, with his persistence, with a retrial, they found no concrete evidence for him did that. So he was eventually released, and he was also talking about the compensation possibilities. But then the question is, how big a scale can China at this moment handle the possibility of retrials? As we all know, if the practices earlier were not as acceptable as we have just discussed, then there might be quite a percentage of miscarriages of justice or wrongful convictions. So to what extent can you provide justice to those who are innocent? And to what extent, in fact, they are being forgotten in the corner, in the dark corner?
Yeah, you know
Professor
that those wrongful convictions discovered in past years in China mainly happened in 1990s or even in 1980s. Some of them happened, you know, early 2000. But the problem is the criminal justice system has already created those mistakes. So we have to find a way to
To correct
redress,
it.
Yes,
to
right.
correct that.
Exactly.
And how many wrongful convictions have
Nobody
happened?
knows.
Nobody, even in the United
Yeah,
States. You
many,
know,
many.
2011, I was invited to participate in international conference on wrongful convictions in Cincinnati, United States. And I was told since mid-1990s when the Innocent Project was established
Yes, yeah.
in New York, Illinois,
yeah.
and until 2011, 271 wrongful convictions were discovered through DNA testing. And there were also some other kind of. So altogether, there might be some 700
So
wrongful
your point
convictions.
is, Professor?
In the United States, that's quite a lot, but only part of the wrongful conviction happened. So some professor in the United States made study on wrongful conviction rate. They say probably 1% is a rate of wrongful conviction.
That's in the U.S. possibly.
In the U.S. So you know that each year about 1 million persons would be found guilty in the United States.
So what about my question, Professor? To what extent can you provide justice back to those who are really actually innocent? And to what extent they are being forgotten in the dark corner? And whose right is it to choose whether this person will be retrialed and that person would not?
So we have the institutions within our People's Procuratorate and the People's Courts. They call petition department of the Supreme People's Court. They would take all the petitions, and also they would review the case. In fact, the case you mentioned, that last May, I was invited by the Supreme People's Procuratorate as an expert to evaluate the evidence in the case. We found the evidence was not sufficient. So our conclusion was that the case should be retried.
But how
by
many
the court.
cases can you review?
Very little. So this is the problem in China now. And you know,
The
we
scale
have
of the issue and the capabilities so far of the legal system to handle it for retrial. Mr. Smith, very brief response from you, then we go to a break.
What I'm thinking is they need to prioritize this case in some way. Like, I'm understanding China is doing much more with DNA testing. They're also improving their forensic sciences, improving the way they investigate crime scenes. So you take the most egregious cases first, those people that more obvious that something is not right with this case, and maybe try to work your way down and get the system kind of honed more to perfection. But the DNA is what's helping Project Innocence get everybody, not many people, out of jail. And I see, you know, working as both a prosecutor and a public defender, I've seen how important it is for the police to be trained. You go to a crime scene, you know how to collect your evidence, you know how to preserve your evidence, that kind of thing. So with training, the system will also improve here.
There are many details that need to be taken care of throughout the system. We're going to continue our discussion, gentlemen, about this very important issue right after this break. We'll be right back. Welcome back. You're watching live edition of Dialogue. With me in the studio once again, we have Lex Smith, who is a foreign legal consultant here in China, and also Professor He Jiahong from the Law School of Renmin University. Our topic today, of course, is a very important one: how to prevent the wrongful convictions here in China with further guidelines and detailed instructions. Earlier, we've been discussing what are the loopholes in the system and what might be the way to correct it. And we see, though, from a political background, that the current administration with Mr. Xi Jinping and Mr. Li Keqiang has been emphasizing once and again about the importance of preventing wrongful convictions. Mr. Xi has been talking about ensure judicial and procuratorial organs exercise the judicial and procuratorial authority independently, fairly, and in accordance with the law. Mr. Li Keqiang, though, has been talking about that the so-called labor reform system should be, or the labor camp system should be definitely reformed. So you see quite strong convictions coming from the party leader, and you could also say from the country's leader. But how long a process would that take before we can say we might be partly reaching that goal? Professor He.
I think first I would like to say that this reflects the good side of the wrongful convictions, because the wrongful convictions would push people to think about the loopholes in our legal system. Otherwise, people would say our system is okay, you know, everything is running well. But with those wrongful convictions, people say, what happened? How can we convict those innocent persons?
All right, there's
So
already a wake-up call.
Yes.
Yes.
Okay. So the leaders are awareing the problem. It's not only the problem of the system of criminal justice, but also the social problem. But judicial independence is very important. There are many other things. For example, we need specific rules to deal with the evidence. In fact, we have been improving our rules. You know that with the wrongful conviction cases happened or discovered in 2010, Zhao Zuohai's case in Henan province. Then the central agencies jointly issued 2 rules regarding with criminal evidence. And last year, you know, we amended our criminal procedure law.
Right.
So we have some provisions about just like, you know, the privilege against the compulsory self-incrimination.
Yes.
Yeah, so we put it that in our criminal procedure law, and also we have more detailed exclusionary rules against the illegally obtained evidence. So nowadays, if it can be proved the confession is obtained through torture, it will be absolutely excluded in the trial.
On the one hand, it is extremely important to prevent wrongful convictions. On the other hand, though, there might be pressures, enormous pressures coming from the general society, from the press as well, to make sure that would happen. However, during this process, this pressure could also work the other way around, which is giving more pressure to the legal system and also to the legal bodies here in this country. And as a result, they might be making decisions that eventually would be found wrong also as a result of the social pressure. So how to make that balance is also a very important issue. We should not only emphasize on one thing, but also both sides.
It's definitely true. I guess I kind of fear what may happen eventually is there's always been so much pressure to get convictions no matter what. Get the numbers. And if you start holding people liable, the judges and the court and people liable, then all of a sudden, okay, maybe things will switch around, like you say. Now we won't convict anybody because we're afraid we'll have liability against us. So it might work kind of the opposite. So there's got to be a balance there. You've got to protect the court and protect the police, but you also have to protect what's going on with the, make sure the criminal cases are fairly and accurately tried and the results are good as many times as possible to reduce appeals. So.
Professor He.
Yes, one thing is that how to guarantee the judicial system to make a decision independently without the influence of the public opinion of the media. And in those wrongful convictions, we would often see the family of the victim, would collect a petition letter, asking the fellow villagers to send that. It puts pressure on the court and on the local government. This is one cause for the wrongful convictions. But at the same time, I think we have to see the public opinion, the media, may also play a very good role, to prevent the judicial corruption and also to prevent the infringe of those cases by the leaders, of the local government. So this is the balance we have to try to find, to strike. And also for wrongful convictions, according to our empirical study, that another problem is we have to find the effective way to redress the wrongful convictions. But as you mentioned, the liability or responsibility of the decision makers in those wrongful conviction cases, it may also create an obstacle for correcting the wrongful conviction. Because they were police officer, prosecutor, after 10 years, they were promoted at a very important position.
Right.
And therefore, would they be able to make that very important decision while they're still sitting in that chair? That is certainly another big issue. There are many issues related to how to prevent wrongful convictions, while at the same time to make sure the legal system functioning independently and fairly. We want to thank both of you, though, for providing your advice and your insight. This is a very long time project that we're talking about here in China particularly. Thank you, Professor He Jianhong, and thank you very much, Mr. Lex Smith. Thank you so much. And thank you for watching. I'm Tian Wei in Beijing. Thank you.